Good morning, everyone. My name is Scott Hernandez. I'm Manager of Business Development here at the Climate Action Reserve. I just want to welcome everyone for this morning's webinar, the special topics webinar on buying offsets for compliance with California Cap and Trade. We've got some really great guest panelists this morning that are going to talk specifically about their kind of perspective in securing compliance mechanisms and in particular offsets to meet their compliance obligation, as well as how that market might function, some of the contracts and deals that are going forward. So just a couple of remaining items to address before we get started. So first of all, I just want to ask if everyone can hear me on the line, if you can raise your hand so that I can know that my voice is coming through okay. Okay, I see some hands coming up, so it sounds like the audio is working just fine. Next, with regards to kind of how the webinar is going to work, I'm going to give a short presentation on kind of the role of the Climate Action Reserve in serving as a registry for the Cap and Trade program. Then next we'll have Graeme Martin from Shell Energy North America kind of talk about their role as both a regulated entity, but as well as a trading entity, and how they see the market going forward for compliance offsets. And then we'll change tacks a little bit. Obadiah Bartholomy from the Sacramento Municipal Utilities District is going to talk about their kind of perspective as a publicly owned utility, and talk about a request for offsets that they a bid solicitation they put out in July, and kind of their experience with that. And then as we close, we're going to talk from an offset developer who's going to talk about how they're generating offsets from projects from the destruction of ozone-depleting substances, and how they aim to serve into the compliance market. So with regards to question and answer, since we do have a large number of attendees on the line, we will kind of save all the questions for the end, and then we will, but if you'd like, go ahead and type in your questions as we kind of move along in the webinar, and then we'll address those questions when we get to the end of the presentation. So thanks again for all of our panelists, and I will go ahead and get started. One quick note, just to put this out there, because we are not the implementing authority of the California Cap and Trade regulation, we just want to note that our interpretation of the regulation could be interpreted differently by the California Air Resources Board, which has the sole responsibility of implementing the regulation. So I think just to use this presentation, as guidance, that this shouldn't be considered legal advice. So with that, I will get started with a short introduction of the Climate Action Reserve and the role that we aim to play in the California Cap and Trade program. So who are we? Here's a little background on the reserve. We are a North American carbon offsets program. We focus on developing project-level emission reduction protocols and generating emission reductions from those projects, serving the voluntary, compliance, and pre-compliance market. Clearly today the focus is going to be more on the compliance market. And kind of how we do that is three kind of key roles, is developing offset protocols for different project types, and kind of mimicking the regulatory process, and then also managing independent third-party verification of those projects, overseeing the verifiers, training them, and then operating a transparent registry system by which all the projects, project documentation, monitoring reports, verification reports are all available and accessible to the public in our registry system. And the idea is that you can go into the system, see a project that you like, contact that person directly, and then we also anticipate that we will be an accredited offset project registry for the California Cap and Trade program, providing registry services for compliance offsets. So just to touch a little bit on the California Cap and Trade program, it is a regulation that resulted from Assembly Bill 32, AB 32. And the aim of it is to reduce to 1990 levels statewide greenhouse gases by 2020. The final regulation was adopted in October of last year. It will go into effect in January. It will run through 2020. It's divided into 3 compliance periods. The first compliance period being a narrow scope, focusing solely on large stationary source emitters, such as refineries or large industrial facilities. And then in January of 2015, the scope will broaden into include transportation fuels, electricity. At that point, when we enter into the broad scope, 85% of California's economy-wide emissions will be under the cap. So how do you comply if you are a regulated entity? So there's 2 ways to comply. Basically, for all of your emissions, you have to true up with the state and give either an allowance or an offset for each ton of emissions that you emit in a given year. So allowances are basically state-issued permits to emit 1 metric ton of CO2 equivalent. And then offsets can be used in place of allowances on a limited basis. So to focus and narrow in a little bit closer on offsets and how they're to be used for compliance. So there is an 8% limit of the use of offsets for any regulated entity's compliance obligations. So I think a good back-of-the-envelope example of this is if you have a facility that has 1 million metric tons of CO2 emissions in a given year, then for that year you could use 80,000 offsets to satisfy your compliance obligation with the state. So as of today, there are 4 approved project protocols that we developed and have been adopted by the California Air Resources Board. Those are our forestry protocols, as well as livestock methane capture and destruction, and the destruction of ozone-depleting substances, which I think we will kind of focus on a little bit later as Patrick Pfeiffer from ES Climate, I think, will talk a lot about the ODS component. So the project must be registered with a CARB-accredited registry. So we've already submitted our application to serve as an official offset project registry, and we anticipate that we, will receive accreditation in the very near future. We anticipated late September, but now that it is late September, I think we'll just say fall. So there are 2 different types of compliance offsets that can be used to comply, or can be used as compliance offsets under the AB 32. So early action offsets are basically offsets that have been listed and earned credits according to our reserve project protocols, whereas compliance offsets, which have a horrible acronym, but it seems to be gaining traction, so I'm committed to use it for this presentation, registry offset credits, or ROCs. And so compliance offsets, or ROCs, are basically projects that have been listed according to the ARB's compliance protocols. So that means that instead of listing under a forestry project protocol, they actually list according to the ARB forestry project protocol. Now, early action offsets, or EOCs, it's a hard acronym I'll kind of delve into on this next slide. So again, early action offset credits are basically climate reserve tons, or CRTs, generated from the reserve's early action protocols from 2005 through 2014. they have to be listed by January 2014. Whereas again, rocks are actually CRTs that will be generated from projects listed with an accredited offset project registry, but according to the ARB protocol. So one of the advantages of using rocks versus early action offset credits, and I tried to make a graph here to illustrate a little bit, is that if your project is listed according to the ARB protocol, the protocol they adopted, then you don't have to do an additional desk verification when you want to convert them into ARB offset credits, or RBOCs, which is the form they will take when they're put into any regulated entity or market participants compliance instrument tracking service system account, which is another great acronym, but we call it the KITS account. So basically those are the accounts that you would have to register with via Resources Board, and when you take an offset credit and you want to use it for compliance, then you'd have to transfer it from an official project registry into your KITS account. And again, that stands for Compliance Instrument Tracking Service System. And in contrast with early action offset credits, there will be a desk verification, kind of a second verification before it can become an RBOC and before it can be transferred into the KITS account. It will have to undergo an additional verification by a ARB accredited verification body. So just to get a little bit into more detail, and I'm not going to cover all of this information, but I wanted to make it available for both the webinar recording as well as for those of you that would like to download the slides, which will be made available later today on the Reserve website. This basically lists all the information about early action offset credits. So these are vintage from 2005 to 2014, and then below you can see the protocol versions that are applicable to earn early action offset credits from forestry, ozone depleting substances, and livestock. This slide gets a little bit more into the detail of how to convert an early action offset credit into an ARB offset credit. Again, you have to open your KITS account. You have to submit attestation to CARB, as well as all the project information to CARB. And then you have to undergo an additional verification by a CARB accredited verification body, and that must be different from the original verifier that you had when you listed the project with the Offset Project Registry. So just kind of moving on as far as the role of the Reserve and the role in providing registry services. Does it matter where you get your offset credits? Yeah, we really do think it does matter, especially in a regulatory program where you have, significant uncertainty related to buyer liability. Compliance buyers need to understand what you're buying if you intend to use them for compliance with California Cap and Trade. So you definitely want an offset registry that knows what they're doing. The careful work of an offset project registry, can really help minimize risk later on, especially when you want to use an offset credit for compliance with Cap and Trade. So we think that we bring a significant amount of expertise and experience in both protocol development, knowledge of the protocols, and experience in seeing projects listed and dealing with different issues that arise. So again, that kind of concludes my portion of the presentation, and now we will move forward with Graeme Martin from Shell Energy North America, who will kind of give the perspective of the compliance entity. So Graeme, are you on the line? Okay, great. And there you go, you're all set.
talk in a bit more detail about some compliance strategies and, as that relates to offset, some considerations that certainly we think about whenever we're doing offset transactions. So if you could just, that's great. So when we look at the cap for California, you can see that in 2015, it increases significantly as transportation fuel providers and natural gas comes under the cap. And so as this relates to offsets, you can see the difference between the blue line and the red line. The demand for offsets really increases in 2015 compared to the first compliance period. So from an offsets perspective, the program has a slower start, shall we say, in terms of demand for offsets. Similarly, when you look at the timeline, and I'm sorry, I'm getting a bit of an echo here. We'll keep going. Yeah. When you look at the timeline for retirement of compliance instruments, you can see that ARB has made it very much back-end weighted. So you really don't have to retire anything for the first compliance period until 2015. There is a 30% obligation in 2014. For many companies that get a free allocation, that free allocation will be sufficient physically to cover that first retirement. And so again, the need for these credits occurs after the year in which you incur the obligation, which is different to any other commodity. If you wanted to sell natural gas in 2013, well, you need that natural gas in 2013. You can't buy it for delivery in 2015, and that introduces some interesting dynamics to the marketplace. And I think I don't have any vendor price forecasts on this slide deck, but a number of the forecasts that I've seen from the different vendors that do fundamental and other kinds of forecasting, I think these are a big driver as to why prices are forecast to escalate in the future as the cap comes down and as as more and more entities come under the cap as time goes on. You see a lot of these forecasts where prices are expected to escalate in the future. So with that as some background, what I thought I'd do is just quickly run through a few compliance strategies. And the most obvious one and least proactive one would just be to wait, the so-called sort of do-nothing scenario. Wait for regulatory certainty. Wait until you actually need these credits for retirement. And as I said, the first date is either 2014 or 2015. But that does expose you to a certain amount of volatility in carbon prices over the next 2 or 3 years. I'm sure many compliance entities are looking at internal abatement opportunities. That's kind of the point of cap and trade, is to put a price on carbon and encourage activities within facilities to reduce emissions. But to the extent that those opportunities are reasonably expensive for some, then you're into buying compliance instruments. And you can either buy allowances at the auction, or you can buy them in the secondary market. And right now, because allowances don't physically exist, everything has been done on a forward basis. There are some advantages and disadvantages to both approaches. If you look at the forward delivery allowance market, which is primarily occurring on the ICE exchange, there's limited liquidity at present. So doing anything in terms of size is tricky. But equally, you don't have to take delivery of these allowances until, well, the most active contract has delivery in December 2013. The auctions, we haven't had any yet. The first auction is coming up in a couple of months, so we'll see how that goes. But there does seem to be a lot of allowances that will be available, and so my anticipation is that size won't be too much of an issue. But the downside of the auction, of course, is that you have to post cash up front, and then you're sat on that inventory until you retire it for compliance. So pluses and minuses to both strategies. Another option may be to buy options. puts and calls. If your view is that prices are going to go up, a call option may be appropriate. If you actually have a lot of allowances and fear that prices will go down, buying a put it's almost like insurance. But options introduce another level of complexity from a compliance perspective in keeping track of what your net exposure and your net positions are, and so again, it's a more complicated compliance strategy. And then finally, as Scott mentioned, offsets can be used up to 8% of your compliance, and I think many companies will probably take advantage of the cost savings that the offsets might bring. Next slide. So my diagram here is a very simple representation of the concept of an offset rather than abating emissions internally at facility A. Investment is channeled somehow to a project that is not covered by the cap and trade program. That project is then given some sort of credit for the emission reductions they've created, and the credit can then be purchased by the facility. Now, that investment can occur in many different ways. I'm sure there's many developers that are looking for equity and debt and other sorts of financing structures, but the specific rather indirect route of investment and flow of funds is through offtake agreements, and that's what I wanted to talk a bit about now. Next slide. So when you're looking at offsets and either short or long-term purchases, there's a number of considerations that we certainly think about, and this isn't an exhaustive list, but certainly probably the main things to make sure that you've agreed before you really get down to drafting contracts or getting the lawyers involved. At a most basic level, what product are you buying? Are you buying an offset that has been issued by ARB and effectively putting all of the admin and risk and hassle of conversion onto the seller or the developer? Or are you comfortable buying a credit that is already potentially on a voluntary registry and does need conversion? The delivery dates are obviously a lot more flexible with an offset contract because they're not on exchanges, so you pick whatever delivery date works for both you and the seller. And as we saw earlier, given that the need to have these credits doesn't really occur until 2014, 2015, you can try to time those delivery dates to match your retirement obligations. From a volume perspective, there are deals being done for firm volumes. So if you say you want 50,000 tons of offsets and the seller is obligated to deliver 50,000 no matter what, but many projects don't know what kind of volumes they're going to get, and so some sort of volume contingency can be built into the contract, whereby buyer and seller share the risk of the project's success in terms of how many credits will they actually achieve over the time span you're looking at. Then you start getting into pricing and payment terms. Do you want a fixed price? Do you want a floating price? Do you want a hybrid of the two? If you think that prices are going to go up, maybe the fixed price is the way to go. If you think prices are going to come down, maybe you want some sort of index structure. When do you pay is another term that is actively negotiated. There are contracts out there called so-called tear-up provisions, whereby payment is on delivery, but if the program isn't in force on the day of delivery, then there's no delivery made and there's no payment obligation. So from a compliance perspective, if you're concerned that the program may be abandoned at a later date or may never get off the ground, or that's looking less likely now, that's a way of trying to match your hedges with your compliance obligation. But there are other payment structures. So I've seen structures whereby payments are staged and linked to milestones. For example, maybe there's an initial payment for, on contract execution, a further payment once credits have been registered on, for example, the client action reserve, and then maybe another payment at conversion, et cetera, et cetera. Revocation is an issue that is unique to environmental markets. I don't know any other commodity where once you buy it, you may realize that actually what you bought didn't exist. But with California offsets, that there is a time period after issuance where ARB can revoke the offset. From a compliance bias perspective, this obviously isn't ideal, but the market is starting to come up with structures to try to fill that void, and there are companies willing to offer warranties, either partially or fully. And then there's also some regulatory provisions that at least limit the time period over which ARB can revoke. The so-called double verification. If the project's verified twice, then that statute of limitations gets shortened from 8 years to 3 years. And then finally, credit. Once you've kind of gone through all these commercial issues and divvied up the risks between the buyer and the seller, credit is a huge issue, because you can push all of these risks onto somebody else, but if that entity doesn't have the balance sheet to support those obligations or those warranties, then you probably haven't achieved very much. And so credit is one issue that if anything, for us, it takes as long to negotiate as all the other issues, because it is so important. But with that said, I'll leave it there and let the other guys chime in, and look forward to the Q&A later.
Okay, thanks a lot, Graeme. I think that was very informative. And now we are going to switch tack a little bit, and Obadiah Bartholomy from SMUD, Sacramento Public Municipal Utility District, is going to talk a little bit about the perspective from the publicly owned utilities. Obadiah, are you there?
Sorry, I was on mute. Yeah, can you hear me?
Yep, hear you just fine.
Great. Well, thanks again for inviting me to participate, and thanks to everyone that's on the phone. Go ahead and go to the next slide. So I'm going to give a quick overview of SMUD as a covered entity, and just talk a little bit about our emissions profile and our expectations around the role of offsets within that. I'll talk generally about our view on offsets and how they fit in with the compliance framework. I'll talk about recent solicitation we had and kind of what the status of that is. I know there have been some people asking about where that is. I'll give an update on that. And then kind of give our perspective on the outlook for compliance offsets going forward. So next slide. Okay, very briefly, as was mentioned, we are a publicly owned utility. We cover approximately the county of Sacramento, and we have an independent local governing board that's publicly elected. So they're effectively our regulator. We don't report to the CPUC for any kind of regulatory oversight. In terms of emissions, SMUD has 4 combined cycle natural gas fired facilities, 3 of which are also cogeneration facilities and provide steam to industrial partners. In total, those facilities, in addition to some imports we have from the Northwest, bring our expected compliance obligation to around 2.7 million tons. And that varies a bit year to year, depending on hydro conditions primarily. I think the other key thing to understand about utilities is that we've received allowance allocations, but really those were given to utilities to cover the expected compliance obligation associated with retail compliance, and here I'm talking about publicly owned utilities. So this is a nuance within the allowance allocation rules that allows publicly owned utilities to deposit allowances directly into their compliance account rather than putting them through the auction for that portion of their compliance obligation that's associated with retail sales. And because of that, we're explicitly not allowed to use our free allowances to cover wholesale sales obligations. And this is an important factor for SMUD and potentially any other POU that may have wholesale sales, because it means that SMUD is effectively short on wholesale sales compliance instruments, meaning that we'll need to procure some compliance instruments to cover those compliance obligations. And that is important in allowing us to be a little bit more flexible in how we procure allowances or offsets to cover that portion that we're short for. So I'll talk about that maybe a little bit later. Next slide. So just generally, SMUD has been at this a while and engaged with the California Climate Action Registry and then the Climate Action Reserve in trying to move forward with the infrastructure for having an effective emissions trading system, and we view offsets as really being integral to that, both for California, but also as we think about any way of bringing in more broadly the United States and internationally, of course, as we've seen with the European markets. So we've been a long-time supporter of them as a mechanism, but really want to see focus on promotion of high-quality offsets, and that's been really our reason for supporting the Climate Action Reserve over the years. We began a voluntary carbon offset program for our customers, which was designed as a complement to our green pricing program that we've offered since 1997. We began that offset program in the end of 2007, utilizing Climate Action Reserve offset projects, including some from one of two dairy projects that we've developed. So we have a little bit of a understanding of the challenges, in particular associated with small dairy projects and generating offsets from those. So that has led to our being able to procure offsets of several different types of forestry offsets, ozone-depleting substances, and ag-methane offsets, and a few N2O offsets. I think as we look towards compliance with the cap-and-trade system, we are wanting to make use of good offsets projects to minimize our costs under cap-and-trade, as most compliance entities are. And we really, in doing that, though, have to minimize our risk in procuring these as compliance instruments. And we do that. I mentioned earlier about our kind of short position as it relates to wholesale compliance obligation. We're really prohibited from taking any kind of an open position or speculating. So if we have an existing allowance in hand, unless we can come up with a swap structure for that allowance for an offset, it makes it difficult for us to consider engaging in the offset market. However, because we're short as it related to the wholesale side, we are able to look at procurement of offsets for meeting our compliance obligations given our wholesale need. So that's one aspect of risk, is that we can't go longer if we're already long allowances. We, like many, have a lot of concern over this new market. There's a lot of price uncertainty, obviously. We have a lot of debate about whether prices are going going to head upwards or come crashing down through the price floor. And even independent of where prices settle, just the fact that there is likely to be volatility with changes to the regulatory structure or just changes in the overall scope of the cap as we go forward, I think that's something that creates a lot of uncertainty internally around the use of these instruments and the value of these instruments as it relates to allowances. The last thing is kind of concern over legal challenges or regulatory delays that might reduce the value of these offsets or eliminate the value of these offsets. So some of these things that Graeme mentioned, and I just want to reiterate that as a compliance entity, we're really wrestling with how to evaluate the value of offsets in the face of this much uncertainty. And so that's a big part of our discussion as we move forward with procurement of offsets. Next slide. So in late July, we put out a request for offer seeking up to 200,000 tons of offsets per year, which is approximately 8% of our expected compliance obligation. We had proposals due at the end of August, and we received a significant response to the RFO, quite a number of proposals from a very good number of different parties. I think probably the main reason I think we got such a good response is we didn't require any bid deposits or credit guarantee as part of the offering process. As we move to the short list, we'll be evaluating more completely the offerers and their prospective credit risk, and if necessary, including terms as we get into negotiations around that. But I think at this point that's not necessarily our intent to do that. The short list was supposed to be out last week, and we've gone through a few different ways of looking at it. I expect that short list is going to be forthcoming. However, I don't expect we're going to be making a public announcement. We'll be notifying those offerers that are on the short list, and then notifying those that were not on the short list that they're either in a we may call you to follow up type of a list, or that your offer is not going to be looked at this time type of a list. So I expect sometime in the next week or so that we may be moving forward with notifying the offerers on that. Some of the risk abatement measures that I'll just mention briefly, we did require offerers to cover conversion of early action credits to CCOs, and we also requested that they be double verified. Some offerers, most offerers did provide that double verification as part of their offer. Some also provided a fully guaranteed or warranted product, kind of guarding against any kind of action that could impact the value of that credit. I think SMUD's intent is really to try and seek guarantees against legal injunction or regulatory invalidation from the sellers. So those are kind of the two primary mechanisms that we have concern about and want to protect against as part of these deals we'll be looking to structure here in the next month or two. Next slide. Okay, just in terms of outlook, I know currently we have a lawsuit out there that's creating some question around the ultimate role of offsets as a compliance mechanism. We are expecting that will be resolved, and that offsets will be able to move forward as a compliance instrument, and expect that they'll continue to maintain a lower cost than allowances even after some of these risk elements are eliminated. the significant uncertainty around the price of allowances is really challenging for decision making internally as to some of the issues that Graeme mentioned of fixed price versus floating price deal structures and the value of each of those. We've had a lot of discussion around the price floor stability in this new regulatory market, and some of our concerns just have to do with an overall uncertainty of the ultimate emissions levels and the total number of allowances allocated. And we hear people talking about there being over-allocation and under-allocation. And so it makes it pretty difficult for us to have confidence that the price floor in the secondary market is going to hold, at least in the early part of the program. That's something that I think there's a lot of concern about. Ultimately, I think with the structure ARB is set up, it will be an effective price floor, but there's question about in the early part of the program whether or not it's going to be as effective. The credit attributes of the counterparties and the regulatory stability of the individual offset protocols and offset mechanism are challenges that we think are going to be ongoing as we move forward. In particular, the credit attributes as we try and seek more significant guarantees or warranties of the products is going to be a challenge, and it's going to be something that we place a lot of focus on in the negotiation to make sure that we're confident that the entity will be there to backstop the product that we've transacted with them for. Next slide. One of the other uncertainties that we're dealing with is a question about new offset protocol acceptance by ARB, and a question about when the right time is to procure offsets. It's a significant question. We hear that they're intent on approving additional offset protocols, but we've heard that for a good amount of time, and so it's really uncertain when that is likely to happen. And as it does happen, we do expect that there will be significant impacts to the supply and demand for offsets, as we see likely a lot more entities seeking offsets over the next 6 months, and then as additional protocols are approved, depending on which ones and the volumes associated with those, potentially influxes of significant supply that could change the price dynamics of the offsets. So that also creates some uncertainty around the fundamental discount that we would expect to see associated with offsets relative to allowances. The last thing I'll mention is that we're still kind of trying to understand what the optimal procurement mechanisms are for SMUD and what our best role is in the supply chain for the volumes that we're seeking. So that's something I think we'll be exploring in addition to this RFO, looking at other mechanisms as well. I expect many entities will be doing that. We participate in power markets and gas markets in different roles in different parts of the supply chain, and I think the offsets market will be no different than that, with some opportunities to engage through different avenues. So that's something we'll be seeking to understand here in the early part of this program. Next slide. So just to conclude, I think we're obviously, like many of you, eager to see a robust offset market develop early in order to be effective in containing carbon prices. We do see a number of risks, but are also seeing effective contractual mechanisms be developed to mitigate most of those risks. There is a lot of uncertainty around the value of this commodity, and really about the allowance market fundamentals that I think is going to be better understood over the next year, as are things like conversion and reversal risks and costs. I think the regulatory and legal dynamics are really going to be key ongoing barriers that are probably remaining after those first set of issues are resolved. And just as a final thought, I think, as many of you would note, if we don't move forward with offsets, it's going to be really a lot more difficult for them to realize their promise of being able to contain prices within the allowance market, as we're hoping they can. So that's it. Thanks.
Okay, thanks very much, Obadiah. And I got your contact information here. Okay, so our next speaker is going to be Patrick Pfeiffer from EOS Climate. They are a project developer and a provider of offsets, and he's going to talk a little bit about serving into compliance buyers. So Patrick, are you on the line?
Thanks, Scott. I appreciate it.
Great.
First off, thanks to the previous two panelists, SMUD and Shell, for providing in a sense, the demand in the market that allows a company like EOS to have recipients of our products. So we thank them and look forward to a robust offset market as well. What I'm going to discuss today is both what exactly is an EOS ODS, ozone depleting substance offset project, and how we are interfacing with the market and vice versa. Slide, please. But before we get there, I think it's important, with a lot of acronyms floating around, that we look a little bit behind the curtain on exactly what is ODS. ODS became popular in 1987 when the Montreal Protocol was passed, an international treaty to decrease the amount of ozone-depleting substances released into the atmosphere. In 2005, the IPCC report on ODS, in addition to identifying chlorofluorocarbons and other refrigerant-type gases as ozone-depleting, they also have extremely high global warming potential. And from this focus led to the revelation that it would be important to not only limit their activity in the atmosphere, but also to find ways to decrease. In 2008, 3 EOS founders responded to that program and that problem, in creating EOS Climate. Moving on to 2011, the Air Resources Board has adopted the ODS protocol, and we look forward to following that to the T as the program continues on. Slide, please. The work that EOS has done to date, just for background's sake, one particular award that we've received is the California Governor's Environmental and Economic Leadership Award for our work in destroying ozone-depleting substances, and we've gotten some nice coverage on our work as well. Slide, please. Because of the winning of the Governor's Award, we were actually featured on the Air Resources Board website, but more in particularly, if you look in the picture, that is one of our VP of Operations, Todd English, who's actually working with a refrigerator, and we'll discuss a little bit more about the project cycle behind ODS and really what entails the creation of a CRT and further a California eligible offset, and how we plan on creating more of those. Next slide, please. So while there's many different components to what defines an offset, I thought I'd take a quick look at additionality and what makes ODS an additional offset, and when we're focused on domestic stockpiles or domestic appliances. Traditionally, ODS is found within old appliances before 1996, mainly old refrigerators that are using refrigerant gas number 12 and 11. Some of the brand names out there are Freon that you might have heard of. So traditionally what would happen is that these appliances would come in to demanufacturing yards. The gas would be pulled, it would be reclaimed, and then it would be recycled into the HVAC market or other kind of appliance market, so you can refill the machine that has been using it. Traditionally, though, these machines are now old and outdated, and their efficiency is well below 100%. So instead of having a perfect closed cycle, the majority of these gases end up venting into the atmosphere. So where EOS intersects the process is after these gases are pulled from different appliances, we work with different supply partners to then redirect those gases to destruction. The destruction is accurate to 99.99%, and that creates a verifiable, permanent, and real emission reduction, which we then bring to the carbon market. Next slide, please. So the case study is a lot of different refrigerators will come in. We'll work with our appliance manufacturer to pull the gas from those refrigerators. We'll aggregate it at an EPA-certified reclaimer, and then we'll bring it to Clean Harbors in Arkansas for destruction. From that process, we'll then go through verification and be able to create a verifiable carbon credit. Next slide, please. So this is a picture of one of the facilities that we work with to help demanufacture a refrigerator, and those arms are actually refrigerators on there, and so it's a very mechanical process, but you can also see in the background that there's a gentleman in there who's working on extraction of the actual gas from these refrigerators. So when you take these refrigerators and you multiply them by, say, hundreds of thousands, you get a good quantity of gas to work with. And the unique thing about ODS as an offset project type is it's really a production cycle. When you look at other offset types like forestry, for example, it's almost a perpetuity that the tree plants and it grows, whereas ODS, there's an input, there's a production cycle, and then there's an output. Next slide, please. So from this work with appliance demanufacturers and other companies in the reclamation markets, we've been able to create over 2.3 million CRTs, and that was done through the Climate Action Reserve's ODS protocol. All 2.3 million and above are eligible for conversion into CCOs, and I apologize about the different acronyms. I too hope that we'll come up with a standardized one, but in this case, CCO is referring to a California carbon offset, and which will be eligible under the Air Resources Board. But before we get to that point, I think it's important to take a look at what is required. And going off some of Scott's previous notes, it's important to figure out what needs to be in place to take the over 2.3 million credits that we've produced and convert those into California eligible offsets. So I'm going to discuss a little bit about the timeline, the process, and then what we do in the interim when we cannot produce a California eligible offset, but we have the underlying product, and then address some of the outstanding questions that are still left. Next slide, please. So we thank ARB for adopting the ODS protocol. We're still waiting on final guidance from the Air Resources Board, and I pulled this from their website. Additional information about early action offset credits will get posted on the early action offset credit page, which is coming soon. In our mind, that's going to be the playbook for exactly the step-by-step process and how we convert the 2.3 million CRTs into ARB-approved offsets. But we have a pretty good idea of what needs to be in place before that can happen. One, the compliance instrument tracking system, KITS, needs to be in place. We're pretty sure that that's, if not there, almost there. Registry approval, as Scott mentioned, the Climate Action Reserve is one of the companies going through, but we need a registry to be approved by the Air Resources Board so that those early action credits can then be transferred over to the compliance system. In addition to that, we need verifiers and verification bodies. So we need the actual verification body to be approved, and then the individual folks who are verifiers at the verification body need to be approved. Various verification bodies have submitted applications to ARB already, and the training has commenced. We actually sent a couple of our internal operations folks to some of those trainings, and we should expect further update from ARB in October of this year on when we will see those the stamps from ARB on those processes. Next slide, please. So when interfacing in the market in a time where you don't have the final product that's expected and eligible for use under AB 32, we still have to come up with ways to transact with the market. And I thought in order to demonstrate some of the transaction structures out there, it's important to understand what the actual process is from converting a CRT or an early action offset credit into a California carbon offset. So right now we have an early action offset credit. We produced over 2.3 million. And through an added process, which most likely looks like an additional oversight of our work, of our previous work by a verification body and a verifier, we'll be able to produce a California compliance offset. The number 8 after the CCO is the liability associated with the offset. If you just have a standard California compliance offset, the invalidation curve, as I call it, lasts 8 years. So therefore, the liability is on the buyer, and that the liability lasts for 8 years. After 8 years, that liability disappears. The Air Resources Board, though, has indicated that through the rules and regs that we can reduce that liability by 5 years. So it's, in a sense, almost like adding 5 years of insurance onto the product. And that's through a double verification. And then after that double verification, we'll be left with the CCO, California Compliance Offset, with only 3 years of liability. I stop there because every other process after that is contractual. And our goal at the end of the day at EOS is to provide the strongest compliance product possible under the law, and that's what we feel is a CCO3. The next chart down below, from CCO8 to CCO3, is what we expect the process to look like once we can just generate a compliance offset right from scratch. So rather than having it verified once through one of the offset project registries, we'll go right to generating compliance offset credits, in which we'll have an initial verification to get a carbon offset, a California carbon offset, and then a secondary verification to reduce the liability. My disclaimer is, I'll read it. This is EOS Climate's understanding of the process. At the end of the day, the Air Resources Board has the final say in this, of course, so we're looking to them for final guidance on this process as well. You should too. Next slide, please. So the sales slide is actually the same as the early action offset conversion slide, because transactions in the market mirror the regulatory developments and the evolution of the market. In interim stages, it's important for us to be flexible. And so right now the market is demanding a transaction in a certain type of structure that allows a deliverable of a product, and then at the same time allows conversion into a compliance grade product. Next slide, please. Okay, so the transactions that we're seeing in the market and are requested these days have different thresholds and different hurdles. The first hurdle would be the delivery of a CRT. Once that's done, next slide please, we'll then have conversion to a CCO8, which will then be considered the next hurdle, and then the final slide please, then we'll have produced a CCO3. So if we mirror that, next slide please, we'll see the same process from the direct generation of carbon offsets under the California program. Next slide, please. And then we'll be able to generate CCOs, the CCO3, in 2 steps rather than 3. Next slide, please. One more. Perfect. So when we look at the transactions today in the market, there's a payment up front for the CRT delivery. And I'll stop there for a second because Graeme and Bartholomy brought up a good point in that there is certain risk in the market about who you're dealing with and who you're contracting. We've had a lot of great feedback that companies are happy when they can receive a product that they're purchasing, and so when you're delivering a CRT, you're able to deliver a product right away. And so a lot of the market has been requesting the actual delivery of the CRT, which can happen today. And the CRT is the underlying that's going to allow you to create a carbon offset. So once you deliver the CRT, there's a payment. And then there's the next milestone, which is the conversion into a California carbon offset with an 8-year liability. And there's a second payment there. And then there's a third payment that occurs once you double verify. At the end of the day, you'll have a summation of, you'll have a price which will equal your CCO3. Next slide. This transaction will be mirrored, but it'll start eventually at just creating a California compliance offset, and then you'll double verify it, and then you'll just have a 3. Next slide, please. And finally, you'll get to a point where you'll just be able to sell double verified products. That's pretty much it. There's a lot of details left that need to be answered. I think the important takeaway is that at least all the credits that we've created are eligible for early action compliance, and which basically means that we can convert those into the Air Resources Board credit once the system is fully up and running. If you find yourself with one of our credits out there, please feel free to reach out. We would love to help you in that conversion process. Please let me know if you have any questions. Thank you.
Okay, great. Thanks a lot, Patrick. That was really, really interesting. And thanks to Graeme and Obadiah as well. So at this point, I'm going to open it up for questions. So if you're, I know we're kind of been going a little behind schedule, but I'm going to just keep it open for another 10 minutes or so. If you do have any questions, feel free to type them in, and then I'm going to go ahead and start seeing what questions we do have. Let's see here. Okay, so I have a question. For the early actions, do those go back to 2005? Yeah, those will be CRTs from eligible protocols from 2005 to 2014, as long as they're listed. I believe they have to be on listed prior to January 2014. And then they can be generating those credits. I've got a question. Actually, oh, here we go. And the geographic scope. So this is from David. What are the geographic scope of eligible projects? So the Air Resources Board has said that any of the approved protocols can have projects anywhere in North America, well, particularly the United States. So right now there's no scope for foreign projects, even if they are using approved protocols. And a question for Graeme. What does Shell mean when it lists WCI carbon as a sub-bullet under emissions? Graeme, if you're on the line.
I am. Can you hear me?
Yeah, I can hear you just fine.
Yeah, that might be a little bit optimistic. But WCI stands for the Western Climate Initiative. Right now, the only products that have, or at least I've seen trading, are California specific. But Quebec does have a regulation that I believe has been passed and due to start their compliance program January 1st as well. And there has been a lot of work over the past year to link those two programs. If that were to happen and you had allowances that were issued by either Quebec or California and they were effectively fungible, then you might see a WCI fungible carbon product transacting in the marketplace.
Yeah, and that's right. And it seems like with the linkage delayed with Quebec that it's still going to move forward, but they're kind of holding off due to the legislation that went through requiring Governor and Attorney General to approve any linkage. For Obadiah, I have a question from Charles asking if you could elaborate on SMUD's concerns about the allowance price floor. I guess in particular, what circumstances do you feel would cause an allowance to drop below this floor, and how likely is that scenario?
I really can't comment on how likely this is to be, but if there is a condition of oversupply and inadequate liquidity in the market, and in addition to that, regulatory uncertainty, I could see, and we have discussed internally, the possibility that the secondary market could drop below the price floor. The price floor, as it stands, from our understanding, is really only effective in the auction mechanism, and so allowances are not able to clear under $10, and the ARB will constrain supply that's released from the auction. But just depending on how many allowances are out there and the urgency of the compliance entities in wanting to procure additional allowances, the amount of banking that is desired to happen, I think there could be conditions where people might view the allowance supply as being oversupplied, even with the amount that ARB has held back. And some of this is tied to, the economic recovery, hydro conditions, other external variables that drive emissions in various sectors. And so some of those variables, if we had a confluence of them, could also drive demand for allowances down. And so I think those are some of the things that we talk about internally, and without a very clear picture of, very recent industrial and electric sector emissions to compare on a pretty granular basis, it's difficult to know exactly how close the allocation is to the expected 2013 emissions levels.
Okay, great. And then I've got a follow-up from Forrest. Will SMUD be pursuing offset transactions outside of the RFO process?
I expect that we will. I think I alluded to that a little bit in the last slide, that we're still trying to figure out exactly what the right procurement mechanism is for this product, given the volumes we're likely to transact. And we're a little bit smaller entity if you look at the IOUs, and so we have a bit lower demand. So it may be that going through a less administrative process as the RFO has been would be a more desirable mechanism down the road.
Okay. Okay, and I'm getting a lot of questions, and this I think happens a lot, about kind of the crystal ball and what ARB is going to do. There's some questions about additional protocols and timelines. I think, Obadiah, you mentioned pretty clearly in your presentation that, and I tend to agree, that they've been saying that additional protocols will be evaluated soon. But I think, at least I listened in on another webinar last week, and it seemed to me that they are pretty busy and focused on launching the program successfully. And I wouldn't expect any other protocols to be adopted before next year. I think they're going to wait until the launch of the program and then start looking at additional protocols. That said, there has been some discussion that the protocols that they do like are, I believe, coal mine methane, rice cultivation, and potentially pneumatic valves and nitrogen management. But that's, again, I don't think any of us have a crystal ball, so we'll have to just wait and see. I have another question coming from Gloria. There's been some talk that the first auction may not happen in November. What's the level of concern amongst the panelists that there could be a potential delay? And I'll just say before I ask the rest of the group, I haven't heard anything about the auction not going forward in November. From my understanding, it seems like they're staying the course. But I'll let the panel jump in on that.
This is Graeme. Michelle, I guess I'll just say that I would be very surprised if it's delayed, but again, nobody has a crystal ball.
Yeah. And it seems that there's, like you were mentioning the tear up, and, there seems to be that the market is already kind of taking into account such contingencies in, different contracts and products, I would say.
And this is Patrick Pfeiffer. I'm just reading an email from Friday, September 14th, where from the Air Resources Board, which is actually giving notice that it's occurring on November 14th, November 14th, 2012.
Okay. Yeah. So again, none of us have insider information, but I think that they're going to stick to that deadline, especially since it was already delayed once. Okay. So just looking at some of the other, again, this is a common question we get: when will the ARB accredit registries, and when will that be announced? We heard, late summer initially, late July. Now we're hearing late September. I was listening on a webinar last week where they were saying very soon, and then backtrack more to in the coming months, and then definitely by the end of the year. So, really, we don't know. We're ready. We're ready to work with them and make sure that there's adequate supply in the marketplace, but we really don't, have any insights of when the accreditation will occur, other than, what they've said in public. So, just looking over, I've got a question about what is the hoped-for time frame of connecting to the EU emissions trading system. I haven't heard anything about linkage to the EU, but I'll put it to the panel. Is that something that you see as likely?
Not in the first compliance period, at least.
Yeah. Okay. All right. Well, it looks like most of these questions are more towards programmatic ARB questions rather than for the specific presentations right now. So rather than speculate, I'm going to go ahead and thank all of the presentations and panelists that we had on today, as well as all the folks on the line for taking the time to join us this morning. It's been a very insightful discussion, and just want to thank Patrick, Obadiah, and Graeme. Thanks a lot for taking the time, and I look forward to seeing how this program goes forward. Thanks a lot, guys.
Thanks.
Thanks a lot.